Hello, I'm Attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin and Kerrigan here in Nashua, New Hampshire. I've been practicing law here in New Hampshire for about 39 years, 38 to 39 years, in the Commonwealth of Massachusetts for about 28 to 29 years. And I wanted to talk today about when a parent wants to assist their child in purchasing their new home. I talked in last week's vlog about the risks and how to protect yourselves if you are actually loaning money to a relative. And I explained how it was important, particularly in New Hampshire, to make sure you don't just rely on that they have a nice home and they have some equity in their property, because if you don't have a lien on the homestead exemption is $400,000. It went up at the beginning of the year. We talked about that. Talked about the change of the business relation, the family relationship between a relative to now a debtor-creditor relationship. That's all in last week's blog. If you wanted general information on that, refer to that. I'm talking today about a parent helping out their child their first home, and there's a variety of ways to do that. First, there could be a gift, and if you're going to be giving a gift to your child, then that's consistent also with what you're if you're providing part of the monies for them and then they're going to have a loan for an institutional lender, that's all consistent. That's with the lender's requirement for a gift letter. They do require that to make sure that that money that you're providing to is provided free and clear of any ties to it, that there's not a loan being paid back, because the lender wants to see their ability to make the payments on their debt. And if there's other creditors out there, they want to factor that into the analysis of whether or not this person is credit worthy for the loan. So if you're actually doing a gift, there's no issue there. One of the things I would want you to encourage thinking about is, if that person is going to be, if you're giving a gift to your daughter or your son, you're not necessarily giving it to their boyfriend, girlfriend, or significant other, or perhaps eventually their spouse. So you want to consider that fact. If you are thinking about that, you may want to think about, well, what happens if the relationship sours? If they're buying a house together, if one of them leaves, you want to make sure that you get that payment goes to your child instead of going to the other person. You can make an arrangement. There's a cohabitation agreement that you could establish, and I've done those for clients that address that when they're not married yet and they're in that situation where they are actually cohabitating. If something happens and they want to sell the property, making sure that that amount of money goes first to your child, and you can arrange for that, and the other person can sign off on it, and they're probably more than happy to sign off on it, because that can be a significant down payment for the house that they're living together. If they become married, you have to change that over to a prenuptial agreement. Um, so there's a different factors, but you can have a very similar agreement, but you can still keep it just simply in regards to that money. Or the two of them can broaden it out to other issues as to the prenuptial agreement. But if you want to make sure that you're giving a significant gift to your daughter or your son, and they get divorced, you want to make sure that that gift is still being provided to the daughter and son. In that situation, when they're married, it's a prenuptial agreement that you want to deal with. So, and we've dealt with those issues in our firm. We can help you in regards to that. So those are the issues with gifts. If you're actually doing a loan, one of the things that I've seen or actually another factor before it gets to loans, is you may just be in a situation where you're providing your name on so that they qualify for the loan. So your son or daughter may not have the credit worthiness at this stage, and they could be they could be providing great credit, but their income might not be the level that they are going to qualify for this loan, and they can still qualify for the loan. In this situation, if you feel comfortable that they can still actually pay the loan, but they don't meet the credit requirements, you can guarantee that, or you're going to be a co-obligor. I prefer you to be a co-obligor on the loan for a parent. So you're a co-obligor on the promissory note. You're also on the mortgage because you're on the deed. And this is the important part of this discussion. If you're going to be providing your own credit worthiness onto the mortgage, onto your child's house, you should be on the deed, and you should then be on the mortgage, and therefore you're going to be getting notices of any defaults there. But you're also going to be in a situation where if something else happens on in that person's life, they have a boyfriend and girlfriend, and they want to give them an interest in the house, or they get married, you want to still have that half ownership interest in the house. You may very well gift that to your son or daughter upon your death. You might even have it set up as what's called joint tenants with rights of survivorship, that upon your death it goes to that person, depending on where you are in your life. But that's a well worth situation to deal with. Lastly, if you're dealing with a mortgage itself, or you're alone yourself, so you're not gifting, you're actually giving a loan to somebody. Your child, what I find usually works best in that situation, if you decide to do that, is a balloon note, where a balloon note is they're not paying anything monthly until maybe 10 years out, or maybe 15 years out, if you can actually deal with that. Consider one of the factors when you're doing that, or gifts. You have other children. What are they going to be expecting? Are they going to be expecting a similar gift when they come time for finding a house? They're going to expect a similar loan in a situation. You may be willing to deal with 10, 15 years of keeping a certain amount of money of yours out of the circulation of your investments, particularly if you're getting an interest rate on that. You might decide to do that. But then times it by your other children, think that about it. But the balloon note is the best way to deal with it, with a mortgage, a second mortgage on the property, to make sure that that they can't go and refinance and get you and take more money out of the property and then not pay you, and then you're just left with an unsecured note. I've dealt with these issues before. Happy to help you. I'm Dan Marr at 603-883-5501, 603-883-5501. I've represented a number of clients of mine that have had loans or loan questions and gifts in regards to their children, and I can help you if the need arises. You can also check out our vlogs. I do my weekly vlogs at our website, NashuaLaw.com, one word, NashuaLaw.com. Go to my personal blog, my personal bio, and then click on to my YouTube channel, weekly vlogs. Look forward to working with you if the opportunity arises. Thank you.